Well, good morning. Thank you very much to Colin and James for organizing this project, and thank you for inviting me to participate. I'm delighted to be here with you this morning, and I'm going to talk to you about climate change considerations for the regional trade agreement between Australia and India. So before I start talking about the specific topic, I just want to note that the most recent information coming out of the Glasgow meeting on climate change is that if we continue with our current policies, we have a 2/3 chance of reaching 2.8 degrees centigrade global warming above pre-industrial levels. And that's just the midpoint of a range that could go as high as 3.3 degrees. I can't go into detail right now, but that would be quite disastrous. So it's really quite urgent for us to act on this. Also, if the climate crisis isn't enough of a motivation for countries to act, we also have measures coming from the EU with their proposed border tax adjustments. Canada is proposing a global carbon tax. So we're certainly seeing movement. Countries are going to want to start addressing this soon. And I think that the trade with countries that are not acting is going to suffer if countries don't get on board. And Australia, because of its coal production, and India, because of its views regarding historical responsibility for cumulative emissions, tend to be climate action resistors. And I can't go into that right now that much, but both Australia and India have a lot of historical responsibility for cumulative emissions. They're two of the top countries in that regard. And India is the third largest source of greenhouse gas emissions currently. If you measure it on a per capita basis, then India drops out of the top 20 in terms of responsibility. So it all depends on how you measure it. But no matter which way we look at it, this is a very serious matter. It requires immediate action. And I would submit that Australia and India really have to get on board. And you might say, okay, well, why should we address this in this one? And especially if the countries resist action on climate change. I would point to the USMCA agreement, where the NAFTA countries made progress with new environmental provisions. And this was even though you had Trump and López Obrador as presidents of the United States and Mexico, respectively, who resist action on climate change and favor fossil fuel interests. So if we could make progress in that political context in North America, I submit that you can do the same thing with Australia and India. So I'm looking at three particular issues. First, I'm looking at the environmental provisions in several regional trade agreements. First, the NAFTA and its side agreement on environmental cooperation. Those are from 1992 and 1993, respectively, I mean. And I'm also looking at the CPTPP, I'm looking at the USMCA, and I'm looking at the new agreement between the European Union and Canada. And so I've basically looked at the provisions that you find in those agreements to see what is on the menu for next generation environmental provisions in RTAs. But I'm also going to look at intellectual property rights for new plant varieties, and I'm going to look at people movement. So if we look at environmental provisions from the NAFTA and the CPTPP and the USMCA and the CanadaEU agreement, here are the sorts of provisions that we want to see in modern RTAs. First of all, if you look at the system under NAFTA and now the USMCA, you have a secretariat in Montreal, the Commission for Environmental Cooperation. It can receive citizen complaints and it can do studies on regional environmental issues. And the citizen complaints can come from citizens of any country regarding failure to enforce environmental laws in any other country. And that's a very useful vehicle for environmental groups, for example, to complain about failure to enforce laws, from logging in British Columbia to the building of a cruise ship pier in Cozumel in Mexico. And these produce factual records on what's happening with respect to the environmental situation, but by publicizing it and launching a formal investigation, that creates political pressure to act to resolve the problem. NAFTA and its side agreement also had a requirement that countries enforce their environmental laws. So if there's a persistent pattern of failure to enforce environmental laws, other countries can complain, and that could be subject of a dispute settlement. The NAFTA dispute settlement mechanism didn't work very well for many years because there was never a roster of panelists appointed. And as a result, it was easy to block the formation of panels. So the system of dispute settlement between governments under NAFTA Chapter 20 fell by the wayside in favor of the WTO. But now in the USMCA, that problem has been resolved. We'll see if it works in practice, but there is a roster of panelists. So I think that means that environmental disputes could end up going there. But the whole thing assumes a persistent pattern of failure to enforce environmental laws in a way that affects trade and investment. And it seems very unlikely that a country is going to complain against another country in that regard, when the countries can simply amend or repeal environmental laws that don't suit them. And that wouldn't be subject to this type of dispute settlement. So I don't think it's a mechanism that's going to be used, but the useful thing I think for this is the citizen complaint system. If you look at the TPP added a lot of climate relevant topics, although they're mostly soft law topics, such as the ozone layer. Ozone depleting chemicals also contribute to climate change. Emissions from ships, which is an emissions issue, including greenhouse gas emissions. Corporate social responsibility, which includes taking responsibility and recognizing fiduciary duties of corporations to address climate change and to adapt to climate change. Trade and biodiversity. The more biodiverse areas of the world are better carbon sinks, and so maintaining biodiversity is important. There's a provision on the transition to a low emissions economy, which is the only explicit climate change provision of that sort. And you have as well trade in environmental goods and services, which is very relevant for adaptation and mitigation for climate change by making sure that you have good distribution of the technology. You also have citizen complaints in the CPTPP, but in that case, it's only citizen complaints against their own government. So unlike the NAFTA system, you don't allow citizens from one country to complain about environmental enforcement in another country. And here, it's really just citizen complaints about compliance with the environmental chapter in the CPTPP. So it's not complaints about failure to enforce environmental laws. If we turn to the USMCA, it's similar to the TPP in that it's also added many of the soft law provisions that the CPTPP has. And there were some improvements over NAFTA, but it continues with the citizens complaint system that we had under the previous system when NAFTA was in force. And it now takes the side agreement that NAFTA had and makes it an environmental chapter of the main agreement. The environmental law definition is now broader because the one under the old NAFTA system excluded commercial natural resource management, which is obviously a pretty significant environmental issue. And so that's now covered. And they've also developed further the definitions surrounding the obligation to enforce environmental laws in each party. One weak point compared to the CPTPP is there's no provision about the transition to a low emissions economy. But since we're talking soft law and all the other areas are important for climate change as well, such as biodiversity, the points that I mentioned regarding the CPTPP, I don't see that as a big problem. The more important thing here is we continue with the citizen complaints where any nationals of any party can complain about the government of any other party to the Commission for Environmental Cooperation. And that can result in a fact-finding report about any kind of environmental situation. And I'd like to see that being used on climate change issues. There's an obligation now to implement multilateral agreements to which each NAFTA, well, USMCA country is a party. But it doesn't include in the list of multilateral environmental agreements, the climate agreements. But there's a provision allowing that to be added later. And so now that the Trump administration is gone, I'm hoping that that is something that will happen. There's also a provision on cooperation on air quality in the USMCA, which you don't find in the CPTPP. And you have support in the United States for the view that air quality issues include emissions regarding climate change. So I'm hoping that provision will be a useful climate provision. If you look at the Canada-EU Free Trade Agreement, it has a broader definition of environmental law. In the USMCA and the CPTPP, environmental laws are defined as being statutes and regulations, whereas in the Canada-EU agreement, it also includes measures, and measures is a broader term, and so it applies to a wider variety of government action. In all of these agreements, they tend to be limited to federal laws when it comes to federal systems of government, which would include Australia, and it also includes all the NAFTA countries. But I don't see that as a major concern. It's one of the limitations that comes from constitutional distribution of powers in federal systems of government. The Canada-EU agreement has many explicit references to climate change. For example, they want to promote trade and investment in goods and services that are of special relevance for climate change mitigation and for renewable energy goods and related services. They also deal with trade in forest products, which is something that the USMCA does as well, trade in fisheries and aquaculture products, trade and investment in environmental goods and services, cooperation on environmental issues such as current and future international climate change agreements. So there's a big explicit focus on cooperation on climate change in the Canada-EU agreement. And I think that's a really important step forward. So if we look at all of these different regional agreements, NAFTA, the USMCA, CPTPP, the Canada-EU agreement, you can see that modern regional trade agreements have a lot of environmental provisions, and many of those are relevant to climate change. And the more recent ones are starting to have more explicit provisions regarding climate change. And I think we can go beyond that in future regional trade agreements to focus on regional cooperation on climate mitigation and adaptation infrastructure, which is absolutely critical. Phasing out fossil fuel subsidies is really important. It's insane to be subsidizing fossil fuel subsidies. We should allow trade measures or even encourage trade measures to deal with fossil fuel subsidies, or certainly dispute settlement. Climate change MEAs should be included, and taking a page from the original NAFTA agreement, I would say we need a provision to say that climate change MEAs prevail in the event of a conflict. Also, we need to move from hortatory to mandatory language, especially regarding climate change provisions. We want to provide that parties have to implement their multilateral climate obligations, and I would include in that their nationally determined commitments and their net zero pledges, because we need to move beyond countries saying, yes, we're going to do something, and then they don't. And if we have an obligation to act on their promises, and we have a system of citizen complaints that can push governments to act on those promises, I think we can make more progress on these issues. So that's what I have to say about how this regional trade agreement needs to borrow from existing regional trade agreements and take a step beyond that. But also it's important to maintain flexibility for intellectual property rights for new plant varieties. A lot of the TRIPS Plus regional trade agreements are now requiring parties to adopt the UPOV 1991 system of intellectual property rights for new plant varieties. The WTO is flexible and allows you to use patents or a sui generis system. Australia has the UPOV 1991. India does not have, does not use UPOV, is not a party to UPOV, and it has its own sui generis system. And I would submit that India needs to continue as it is and not assume any TRIPS Plus provisions regarding new plant varieties. And that's because India has 500 million subsistence farmers. It's vulnerable to climate change. Those farmers are going to need the plant technology to adapt to climate change. And if you have the UPOV system, it favors producers over users of this biotechnology. And that's not what India needs. India needs the opposite. So I would encourage India to continue to resist pressure to join the UPOV Convention. And in terms of people movement, that's really more of an issue for Australia. We know that climate change is going to produce a lot more climate migrants. And India has such a huge population compared to India that you want to make sure that provisions on people movement are a bit more restrictive than they are, for example, in the NAFTA. So if you look at NAFTA and the USMCA, you don't have any restrictions on the quantity of professional visas being issued, and you have relatively free movement of people using professional visas in the region. But I would submit that that's not the case for India and Australia. You shouldn't have that kind of free movement, and you need to maintain the liberty on the part of Australia in particular to limit the number of visas that are going to be issued and to maintain its sovereignty over these issues as much as possible. And that's just because of the differences in population and the gaps in per capita income. If you look at the European Union, where you have free movement of people, you have relatively small gaps in per capita GDP between a country like Greece and a country like Germany. And so you can have free movement of people. If you look at North America, you don't have free movement of people generally, but you do with respect to professionals. And again, Mexico is about a third of the population of the United States. And the gap in per capita income is not such that you have a huge movement of people in the professional class going to the United States. There are no restrictions on the number of people that go. But even if you move beyond professional visas, you have a net migration of Mexicans out of the United States now, which tells you that the level of income in the different countries is such that you can have relatively free movement of professionals at the very least. But if you look at India and Australia, there's a much bigger gap in per capita income and a much bigger discrepancy in the population. So it's better to keep climate change in mind when you're thinking about how much you want to liberalize people movement. So in conclusion, I just want to end by saying the climate crisis is quite urgent. Trade measures are coming to deal with this. And now is the time to get ahead of this and make sure that you incorporate state-of-the-art provisions regarding climate change and climate-related environmental issues in this new free trade agreement. Thank you very much for your attention.